this is a synopsis of the U.S. Supreme Court case, Whitney v. California. 1927 case, Whitney v. California, is going to set a standard for free speech. We have a limit to free speech. You should be skeptical of anybody that just tells you that we have a limit to free speech, but they don't tell you that free speech is also limitless, at the same time. Yeah, it's not absolute, but it is to the maximum extent. It's very liberally, that's, freedom of speech. That's like, I could just yap, I could just go around yelping all day long. Yelp! 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 I could just go up to a police officer and be like, hey, cop, you fucking cunt, cop, you fucking piece, fuck your mother, you cunt, cop, motherfucker. Right, free speech. What are we allowed to say? Yeah, okay, you're going to rush in and say, well, your freedom with the restrictions. Well, what are the goddamn restrictions? And what are the, you're going to tell me what I can't do before you can tell me what I can? Okay, you're going to try to what? Push me down before I even start to walk? Jesus Christ. So Whitney versus California, 1927. It's insane how the Supreme Court gets freedom of speech right when it comes to racist, anti-Semitic, sexist, just low-life, pieces of shit just being, just using all kinds of just really crappy language, wops and mix, wops and mix, Huns. So they get it right with the racists, but then when it comes to the communists and when it comes to the socialists, they get it wrong. So Whitney versus California, 1927. It's a unanimous decision to fuck over Charlotte Anita Whitney. Why? Well, she's a communist. She, tried to establish the Communist Labor Party of America, and she's guilty. That's a crime. She's a communist. She's going to establish a Communist Labor Party under the 1919 California Criminal Syndicalism Act. California is going to say she's a criminal. She's a criminal because the limit of free speech is clear and present danger, and by establishing, a political party that's not your political party, that's not a Democrat or a Republican, well, shit, that's just, that's terrorism. They're going to overthrow the government. What's the point of having a political government or a political party if you're not going to try to get the reins of power? So, the violent overthrow of government is what they were focused on. So they were trying to say, just because this lady, Charlotte Anita Whitney, wanted to organize the Communist Labor Party of America by happenstance, by association, just because communism is associated with some people who want the violent overthrow of government. Therefore, Charlotte Anita Whitney, she was a member of a distinguished California ruling family. She's going to get convicted. She's going to get convicted of this. And they did this over and over again. They went after Eugene Debs and Charles Schenck and Robert Goldstein for making a movie, for giving a speech, for passing out leaflets. Hey, here's a leaflet. Get the fuck in jail, you son of a bitch. I thought we had the freedom of speech in America, not under Woodrow Wilson during World War I. Fuck you. Get in jail, you son of a bitch. So Louis Brandeis is going to concur with the 14th Amendment application, where they go ahead and get the Bill of Rights to apply to the states through the 14th Amendment, but he's going to disagree with the restriction on freedom of speech. So Justice Sanford said clear and present danger standard was used. Went further, that Sanford used the bad tendency test also. So Justice Sanford, 1927, Whitney v. California, is going to say the state can use its police power to punish those who abuse their rights to freedom of speech by utterances inimical to the public welfare, tending to incite crime, disturb the public peace, or endanger the foundations of organized capitalist imperialist government and threaten its overthrow. And that's a bad tendency. Words that have a bad tendency can be punished. So that's what the fuck Justice Sanford laid down with his 1927 Whitney v. California case, right? Charlotte Anita Whitney. Well, she's, was big time, but then she, cared about the working class and cared about the poor people, and she was gonna. Charlotte denied all the charges. She said it's a political party, not terrorism. It's not even in Charlotte's vocabulary to use violence. The defendant's conviction under the California Criminal Syndicalism Statute for membership in the Communist Party apparently didn't violate her free speech rights compared, with Sanford and the Supreme Court of 1927. Apparently by, going and forming the Green Party or the Libertarian Party or the Democrat Party or the Republican Party, just by the virtue of forming the Republican Party, you have so many of these Republican founders who have blood on their hands. Even George Washington's got blood on his hands. That murderer, you're going to institute a government by that murderer? You're going to carry his institutions on? So by virtue of just forming the Republican Party, just forming the Democratic Party, just forming the Green Party. Now, if they were forming the we're going to overthrow the government party, the terrorism party, the let's kill innocent people party, then, you could have a problem. But unless there's specific charter and there's specific threats, this is a ridiculous case. This is so fucking stupid. This is so dumb. They're going to say, basically, just because communism is associated with the Bolsheviks, Lenin is going to, forcibly take over the government. Some say coup d'etat, others say Russian Revolution. Guess depends on where you are in the propaganda warfare. So, Whitney v. California is a bullshit case. It's going to not only use the clear and present danger standard set forth by Schenck, but they're also going to add the bad tendency test too. The bad tendency test. I think it was the 1907 case. When there's some 1907 case, it was like, if you just do bad tendencies, you're going to go to hell. Yeah, 1907 Patterson v. Colorado. And that would be an interesting case to check into, just to show how long and deep the corruption has been here in Colorado. So yeah, let's see, any more about Whitney v. California? She's a terrorist. She tried to form a political party. She didn't, threaten anybody, just went to a room and other people in a room that, wanted to help the poor people. So that's a clear and present danger, and there's a bad tendency if you continue to allow these communists to organize. Eventually they're going to convince somebody else out here, and they're going to become communists too. So the Brandenburg decision is going to overrun all these decisions. So this just, Schenck is fucking bad, case law, and so's this. This is bad case law. And so is the Dennis decision. So Dennis decision is the exact same thing. Eugene Dennis went to go form the Communist Party, gets arrested for the espionage. How is that not an attack on the First Amendment? How is that not an attack on the First Amendment? But they used, freedom of speech. They used the 1919 Espionage Act to chill free speech, to kill free speech. You couldn't even utter any moment of doubt that Woodrow Wilson and World War I might have been a bad thing. You can't even, when people say, I love this war and I love Woodrow Wilson, you got to smile like an idiot. If you have just the moment of hesitation, of a possibility that you might doubt the goodness of the great Woodrow Wilson and his government. He's throwing political dissidents in jail. People are going to say Castro is a bad man. Castro did a lot of good for his people. But compared to Woodrow Wilson, Castro is a goddamn saint. Compared to Woodrow Wilson, Jesus Christ. Castro is, baby Stalin. Compared to Woodrow Wilson. So, make sure Brandeis, he's going to concur, but it's going to be a, one of those backwards concurrence. So he's going to say, I concur with the elements of this case about the 14th Amendment applying to the states, so therefore the states can use the Bill of Rights to the federal Constitution, and it applies to the states via the 14th Amendment, via the Equal Protection Law. So the federal government says it's not just freedom of speech for the federal government, but it's freedom of speech for all the state governments too. Now, Chief Justice Brandeis is going to concur, but he's going to disagree with the restriction on freedom of speech. He says that freedom of speech is a vital element in the heart of a democratic society. So for Brandeis, it is absolutely essential. Freedom of speech is important as a means and an ends. Freedom of speech is important because citizens in a democracy have an obligation to take a part in the governing process. And so how can we take part if we cannot discuss and talk and find out and discover? So freedom of speech is essential to a democratic society. It's a vital element in the heart of a democratic society. So Brandeis is going to introduce the time to answer test, and he's just basically, nobody can be guilty of a clear and present danger test if there's time to respond. If there's full opportunity for discussion, if a person can discuss the matter, then clearly it's not clear and present danger. The greatest enemy to freedom is an inert people. Brandeis, 1927, Whitney v. California. Oh my God, it's a clear and present danger. You say you're a communist? You got time to discuss this? Yeah, you got time to answer? Oh yeah, well what's communism mean? What do you mean by communism? Oh, passing out apples? Make sure everybody has housing? What about the overthrow of government? I keep hearing about the overthrow. Oh, no. Just peaceful elections. Huh. Well, I guess I shouldn't have assumed so much. So just because the person is a communist, they went ahead and fucked him over. But eventually, the Brandenburg decision is going to defend a KKK guy saying a bunch of stupid racist shit. And he's going to basically just say, I'm tired of the blacks, and I'm tired of the Jews, and I'm tired of the government. And he's going to lace it with a bunch of violent rhetoric, like, to hell with the blacks, to hell with the government. We're going to get revengeance on them. We're going to revenge with a vengeance. And the Supreme Court said that that was okay because it was a rally. It was on TV, so they're just, saying shit. They're just being agitators to cause a stir. And they didn't literally mean that they were going to threaten that specific person or that specific building. There was no imminent threat. There was no lawless imminent threat. And so the Brandenburg test is going to stand the test of time, and it's going to overturn the Dennis decision and the Whitney v. California decision. So Charlotte Anita Whitney and Eugene Dennis is going to get fucked over. The First Amendment is not going to protect them because they're communist, and that's it. Just by the virtue of them being you're a communist? Well, my misperception of what a communist is makes you the devil. Right? Lucifer, you devil. You're a communist? You're the devil. Oh, for peace, love. Oh, like Jesus. Oh, well, that sounds downright Christian. Right? Communism sounds downright Christian. Last but not least, Whitney would later on be pardoned by the governor of California based upon Brandeis's concurrence. So this is Brandeis, breaking out of his shell. Eventually you're going to get Hugo Black, who's one of my favorite Supreme Court justices ever, who believes that we have absolute freedom of speech because the First Amendment says Congress can pass no law. And that's absolute. They can pass no law. There's no law that they can pass. They could try to pass a law, but they can't. That says no law. Congress can pass no law abridging the freedom of speech. So therefore, the freedom of speech law is absolute, man. And I've always called myself an absolutist, but I think that threats are acceptable exceptions. So I think there are some acceptable exceptions. But essentially, by being an absolutist, I'm just maximizing. I'm a maximist, I guess. I want as much freedom of speech as possible, within reason, right? So I want people to be able to talk with a vengeance, with just, talk here, talk there, write this letter, write that letter, put this out, publish this. I want freedom of speech all over the place. I want people, whatever value we can get out of speech for it to be maximized and inflated and pervased all across the nation. So Whitney is going to be pardoned by the governor. So, she's going to go to jail, right? 6 months or something just for being a communist? This is the war on communism. Jesus Christ, it's kind of crazy. You only got 2 economic systems in here. People are going to go to fucking jail just for what they believe, just for their ideology, just for their faults. And even if, let's assume that she believes in the communism that overthrows government. But it's a general theory. It's a general vague theory like Mr. Brandenburg, who, wants to attack all black people, hates all black people, probably wishes violence upon them, in his heart, 100%. But he's, lived in society this long, hasn't attacked, black folks, and probably won't. Probably is just using rhetoric in order to, make a point. So unless Brandenburg specifically says that guy, that person, those group of people in that building over there, unless there's a specific plan and a specific people, a specific pathway, if you're just like, you know what, man, these goddamn capitalists, we need to go ahead and then, we need to just destroy them. We need to destroy all these capitalists. That's legal. That's legal per the Brandenburg decision, which the Dennis decision is terrible, right? Clear and present danger to grave and probable danger. Oh, that's different. Clear and present danger. Oh, my God. That guy's got a gun. There's clear and present danger right now. Versus grave and probable danger. Oh, my God. That man has a gun. That is grave and probable danger. But they're going to use clear and present danger. They're going to use grave and probable danger as a way to say you can't be a communist. You can't show a movie that criticizes Britain. You can't pass out leaflets that tells people to resist a draft. You can't be Eugene Debs, and you can't give a speech. You can't be Robert Goldstein, and you can't be, Charlotte Anita Whitney. So Charlotte Anita Whitney is going to get, exonerated, acquitted by history, by the governor of California, and then later on by the Brandenburg case. So what the fuck? 1927 America? Jesus Christ. Whitney versus California. What a waste of taxpayer money. Whitney v. California, 1927. Jesus fuck. The state can use its police power to punish those who abuse their rights to the freedom of speech by utterances inimical to the public welfare, utterances tending to incite crime. Hey, why don't you go burn down all those houses? Hey, why don't you go burn down all those houses? I'm going to utter this, and this is me inciting crime. Disturb the public peace or endanger the foundations of organized government, or threaten its overthrow. Words with a bad tendency can be punished. Words with a bad tendency can be punished. So Whitney v. California is going to put this, communism, not only are they guilty of the clear and present danger standard, but they're guilty of the bad tendency standard too. Whitney v. California, 1920. What was going on in 1927? Oh, yeah, 2 years before the Great Depression. Hey, you know what? We're about to have a Great Depression. What should we do as a nation? Hey, I know. Let's throw Charlotte Anita Whitney in jail. Why? What'd she do? She's, hanging out at the hall, and she's organizing people, trying to get everybody fed, and trying to get housing for everybody. That sounds good. Charlotte Anita Whitney sounds like a goddamn hero. You're going to throw her in jail for what? Well, just to throw the Bill of Rights in trash, you know what I mean? Fuck her First Amendment rights. That's mainly why. I want to fuck her rights over. Why? Well, she's, communist. I'm capitalist. She's different than me, so I got to, I got to deprive her of all her rights. Well, that don't sound nice. That don't sound nice. That don't sound good. That's not nice or good. So yeah, Whitney v. California. It was only 2 paragraphs long. What was this? 10 minutes? I got 2 more coming up. Peace.